Afternoon and hello everyone. Welcome to the Office of Tax Appeals. Today's oral hearing proceedings for the appeal of the cities of Fillmore et al. Is publicly viewable and a stenographer.
Your Honor, can you speak closer to the microphone, please? I'm having trouble.
By all means. In fact, I was just going to talk the stenographer. And a stenographer will transcribe everything that is said. I am Shereen Ridenauer, and I am the lead administrative judge for the purposes of this hearing, and my co-panelists are Andrew Wong and Suzanne Brown. Also present is a stenographer who will be reporting this hearing verbatim to ensure we have an accurate record. We ask that everyone speaks one at a time, does not speak over each other, speaks clearly and loudly, and when needed, the stenographer will stop the hearing process and ask for clarification or for you to speak louder. After the hearing, the stenographer will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. As a reminder, the Office of Tax Appeals is not a court, but independent appeals body that is independent of CDTFA and is staffed by tax experts. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we have a proper record on which a decision may be based and to conduct an orderly hearing. All parties must be courteous to each other and to the administrative law judge panel, and a party may not interrupt another party. Each party will have an opportunity to be heard, so please wait for when it's your turn to present your side. Also, I may interrupt the hearing if we get out of order or become counterproductive, as keeping us on track and creating a clean and efficient hearing record is part of my role as the lead administrative law judge. Just to be clear, do any of the parties intend, pending a showing of good cause, to submit additional exhibits or witnesses? Mr. Cataldo?
No.
Okay. Ms. Varney?
No.
And Mr. Backus?
No.
Thank you. Before we go on the record, are there any questions about anything I've said thus far? Mr. Cataldo?
No questions.
Ms. Varney?
No questions.
And Mr. Backus?
No questions.
Okay, great. Judge Wong, are you ready to proceed?
I am, thank you.
Judge Brown, are you ready?
Yes, I am. Thank you.
And stenographer, are you ready? Okay, we are now on the record. We are opening the record in the appeals of City of Fillmore et al., OTA case number 180118887. Today's date is Thursday, December 15th, 2022, and the time is approximately 1 o'clock. The hearing is being conveyed at Sacramento, California. Today's hearing is being heard by a panel of 3 administrative law judges. My name is Shereen Ridenauer, and I'm the lead judge. Judges Andrew Wong and Suzanne Brown are the other members of this tax appeals panel. All 3 judges will meet after the hearing and produce a written decision on equal participants. Although the lead judge conducts the hearing, any judge on this panel may ask questions. For the record, will the parties please state their names and who they represent, starting with appellant?
My name is Michael Cataldo with Cataldo Tax Law, and I represent the appellant City of Fillmore.
Thank you.
Janice Varney, Vice President of Sales and Use Tax for Muni Services, representing the petitioners, cities of Los Angeles, Ontario, Palm Springs, San Jose, San Diego, and the County of Sacramento.
Thank you. And CDTFA?
Chad Backus with the department's legal division, and seated behind me are Scott Claremont, also with the legal division, and Kathy Stalker with the department.
Okay. Great, thank you. As we discussed and agreed upon by the parties at the pre-hearing conference on November 14th, 2022, and as stated in my minutes and orders dated November 17th, 2022, there are 2 issues in this appeal. They are whether the reallocation of tax is barred under the equitable doctrine of laches, and whether the disputed amount of local tax allocated as sales tax directly to appellant should be reallocated. The following facts are agreed upon by the parties: that the Fillmore office is the only California location at issue as a possible place of business of retailer, that the storage tanks were not owned or operated by retailer, and the fuel located in the storage tanks were commingled with fuel owned by other persons.
Sorry, Your Honor, I'm really happy.
Oh.
Everybody but the guy in the back is loud enough.
Sorry. No, don't apologize. Yeah, okay. All right, okay. The following facts, I'll start there. Does that work for you? Okay. The following facts are agreed upon by the parties: that the Fillmore office is the only California location at issue as a possible place of business of retailer, that the storage tanks were not owned or operated by retailer, and that the fuel located in the storage tanks was commingled with fuel owned by other persons. When the jet fuel was delivered to customer, title passed, and the sales occurred in California. As for exhibits, each party's exhibits are listed in the exhibit log, which was attached to the minutes as orders, as well as in the exhibit binder, which was emailed to the parties. If any party did not get that, would they please raise their hand? All right, hearing none. Appellant submitted exhibits 1 through 16. Petitioners submitted exhibits P1 and P2. And CDTFA submitted exhibits A through D. During the pre-hearing conference, none of the parties raised objections to other parties' exhibits. As such, pursuant to my minutes and orders, appellant's exhibits 1 through 16 were admitted into evidence. Petitioners' exhibits P1 and P2 were admitted into the evidence, and CDTFA's exhibits A through D were admitted into evidence. There will be no witness testimony today. The presentations will consist solely of oral arguments. Also indicated in my minutes and orders, at the close of the hearing, the record will be held open to allow the parties to brief on the issue of buying companies, which was recently raised by appellant. While I originally indicated that the appellant would have 30 days from today to submit its brief, I have since realized that appellant's 30-day deadline would fall on a Saturday of a holiday weekend. So in an effort to allow the parties an equal duration for the briefing on this new issue, I will instead give each party 40 days. Okay. As a reminder to the parties, during our pre-hearing conference, we decided that appellant will have 60 minutes to make its presentation, followed by petitioners who have 20 minutes, and then CDTFA who have 30 minutes. Then appellant will have 10 minutes to provide closing remarks if it chooses. Each party is encouraged to monitor their own time, and I also remind the parties that the taxpayer in this matter shall be referred to only as retailer. Does anyone have any questions before we move on to presentations? Mr. Cataldo?
No questions.
Thank you. Ms. Varney?
No questions.
Thank you. And Mr. Backus?
No questions.
All right. Thank you. Again, Mr. Cataldo, you have 60 minutes, and when you're ready, please begin your presentation.
Terrific. Thank you very much. So I just want to give you a little overview of the topics that I'm going to be covering in my presentation today, starting with just a summary of the case, identifying the agreed facts of the case.
Mr. Cataldo, can you pull the mic closer, please? Thank you.
How's this? Okay,
Great,
good.
thank you.
So I'm going to start with a summary of the case, then lay out the agreed facts, then discuss the evidence in this case, then the economic development agreement, followed by a discussion of buying companies and Regulation 1699. It was H, it is currently I. There's recently been a amendment to the regulation that just moved the ordering, as well as legislation specifically dealing with jet fuel local sales tax allocation where there's one place of business. Then I'm going to go through the Board of Equalization review of the reallocation petitions and the regulations, followed by the latches argument, then applying the local sales tax allocation laws to the undisputed facts in this case, and then concluding with several ways that this panel can decide the case in favor of Fillmore. So for a summary of the case, the airline in this case, and I'm just going to refer to it as airline, established retailer as a jet fuel buying company. A retailer entered into an agency agreement with Inspired Development LLC, where the retailer asks Inspired to establish and conduct a jet fuel sales administration office in Fillmore. The retailer purchased jet fuel from various third parties and resold the jet fuel to the airline through its Fillmore office, pursuant to a master sales agreement between the airline and the retailer. So that is just a sort of a summary of the case. Now, appellant contends that the local sales tax applies because the jet fuel sales were made by retailer from its Fillmore office. An appellant's position is supported by both ample evidence in the record as well as the settled law on local sales tax allocation with respect to jet fuel sales sold by buying companies with a single place of business. CDTFA and petitioners, from what I understand, their arguments are really aligned, so I don't have to address separate arguments from petitioner and CDTFA. We all seem to be, they're all advancing the same arguments. So if I refer just to CDTFA argues, I think you can fairly say that I'm also saying petitioner argues. There's no other separate arguments. For example, petitioners were at one point arguing that there was more than one possible place of business because of the storage tanks. As Judge Ridnour just mentioned, that is sort of off the table now. So what CDTFA is contending is that the jet fuel sales in question here were subject to a local use tax because it claims that those sales were made by a retailer from Houston. Now, CDTFA must show by a preponderance of the evidence that the sales were made from Houston in order to reallocate. And that's Regulation 1807B2, now 35056C3, where the preponderance of evidence standard is. They won't be able to do that. The CDTFA really ignores all of the evidence in the case showing that sales were made by retailer from retailer's office in Fillmore. Now, the agreed facts in this case, the retailer was a buying company. This was acknowledged at Exhibit A, page 1, in the decision and recommendation, second sentence. And what is a buying company? A buying company is defined under Regulation 1699H. I'll be referring to it as H. A buying company, and this is not the entire regulation, I'll be getting into it later, but the gist of it is that a buying company, quote, shall be issued a seller's permit and shall be regarded as the seller of tangible personal property it sells or releases. Another agreed fact is that the Board of Equalization issued retailer a seller's permit in 2006 for the Fillmore location. Now, before I proceed any further, I just want to make clear when I'm referencing the Board of Equalization, I mean, there's a lot of different parties, and the Taxpayer Transparency and Fairness Act kind of added some complications to who I'm going to be referring to. But during the time at issue in this case, there was no CDTFA and there was no Office of Tax Appeals. Both of those roles were handled by the State Board of Equalization. So the State Board of Equalization was in charge of administering the sales tax, issuing regulations, which is now what the CDTFA does. The Board of Equalization also heard tax appeals, both sales tax as well as income tax appeals, which is now what the role of the Office of Tax Appeal is. So the Board of Equalization issued a seller's permit to retailer for the Fillmore location. It now seeks to retroactively revoke that sales permit, and it sort of needs that to happen in order for its entire theory to hold together. And I will just note right now that I'm not aware of any authority that allows the State Board of Equalization to retroactively revoke a seller's permit. Seller's permits, when they're issued, there's rights and responsibilities to having a seller's permit, and the CDTFA's own publications will tell you that. Then there's, under the code, there's revocation proceedings and hearings before a seller's permit can be revoked. It's actually a misdemeanor to sell without a permit. And accepting and issuing the sale for resale certificate. These are all things that you show you can't just retroactively revoke a seller's permit. The point, because I am in the agreed facts here, the point is that the BOV issued the retailer a seller's permit. Now, I know they'll probably disagree as to whether they can revoke it or not, but I just wanted to point that out here. Again, the retailer had no other place of business in California, so we've agreed to that. And finally, title to the jet fuel at issue passed in California. The evidence in this case. The evidence that this panel will need to look at to decide this case is there's a handful of things. One is the agency agreement between the retailer and Inspired, and that's at Exhibit A1. The master sales agreement between the retailer and the airline, which governs the sales of the jet fuel in this case. The purchase orders and authorizations received at the Fillmore office. Those are at Exhibit A7. The master sales agreement, by the way, is at Exhibit A5. And the invoices received at the Fillmore office, which is at Exhibit A8 at page 13. There's also an economic development agreement, which the CDTFA has pointed out in its DNR. So the economic development agreement really is not relevant evidence as far as how the law should be applied. However, you certainly need to know about it because it's relevant to looking at the buying company issue. The economic development agreement was between Inspired and Fillmore. The economic development agreements of localities are legal, and there's been no suggestion that this is not something that can be legally done. The economic development agreement split the local sales tax revenue that would be generated as a result of placing a place of business in Fillmore, 50% to the retailer, 15% to the city of Fillmore, and 35% to Inspired. There's been some discussions and questions about Ryan's involvement. Then they were a tax consulting firm who assisted, and under the agreement they were referenced as having a separate agreement with Inspired, which we didn't have. It was asked for. CDTFA wanted to see it. We don't have it. Suffice it to say, there's some economic development agreement. Ryan was involved. It's our position that how Ryan gets compensated under this economic development agreement has no bearing on this case. Buying companies. So this is going to be a bit of a mouthful, but I think given the importance of this regulation, I'm going to go ahead and just read the buying company regulation currently at 1699I. And here it goes. The definition. For purposes of this regulation, a buying company is a legal entity that is separate from another legal entity that owns, controls, or is otherwise related to the buying company, and which has been created for the purpose of performing administrative functions, including acquiring goods and services for the other entity. It is presumed that the buying company is formed for the operational reasons of the entity which owns or controls it, or to which it is otherwise related. A buying company formed, however, for the sole purpose of purchasing tangible personal property ex tax for resale to the entity which owns or controls it, or to which it is otherwise related, in order to redirect local sales tax from the locations of the vendors to the location of the buying company, shall not be recognized as a separate legal entity from the related company on whose behalf it acts for purposes of issuing it a seller's permit. Such a buying company shall not be issued a seller's permit. Sales of tangible personal property to third parties will be regarded as having been made by the entity owning, controlling, or otherwise related to the buying company. A buying company that is not formed for the sole purpose of so redirecting local sales tax shall be recognized as a separate legal entity from the related company on whose behalf it acts for purposes of issuing it a seller's permit. Such a buying company shall be issued a seller's permit and shall be regarded as the seller of tangible personal property it sells or leases. There's more, but not that much. The elements of a buying company. Elements. A buying company is not formed for the sole purpose of redirecting local sales tax if it has one or more of the following elements. A, adds a markup to its cost of goods sold in an amount sufficient to cover its operating and overhead expenses. And B, issues an invoice or otherwise accounts for the transaction. Now, we're not claiming that we meet A, adds a markup. That's not a fact in this case. But B certainly does apply. Issues an invoice or otherwise accounts for the transaction. The record and the evidence in the record, there's an ample amount of evidence to show that retailer otherwise accounted for the transaction. So to understand why buying companies are so important to this case and really dispositive of this case, we need to look to the history of the buying company regulation. So it was in 2001, the State Board of Equalization opened up a regulation project to deal with buying companies. There had been a lot of uncertainty, a lot of audit disagreements regarding the establishment of buying companies and whether they're valid or not. And they were looked to sort of common law and income tax concepts of substance over form, sham transactions, and it was not really a workable solution. And I will point you to, it's Exhibit 1 on page 6. I'm just going to read from it. You don't have to go there if you don't want to. But this is at page 6 of 13. It's at the last paragraph. There are many factors. Oh, this is an initial discussion paper of the SBE for this regulation project. Quote, there are many factors that must be considered when questioning the validity and the existence of a buying company. These items include, but are not limited to, the breadth of the customer base, invoicing methods of the buying company, whether or not it achieved profit margins, whether those are reasonable, assumption of fiscal and legal liabilities, the existence of a distinct separate identity, employees, accounting, and banking, whether or not the buying company has a proprietary interest in its own facilities, carries its own insurance, and the nature of economic relationship between the buying company and the vendors and the buying company's parent entity. The intent was to address the local sales tax allocation involving buying companies. So very similar to the case we have here, one of the concern that the CDTFA had with buying companies was their establishment, which could redirect the local sales tax to one location instead of it being allocated to many jurisdictions. Staff even recognized, at Exhibit 4, page 3, they even recognized the use of economic development agreements by cities and other localities to do this, understanding that it was legal to do this. That's at Exhibit 4, page 3. At Exhibit 4, page 5, I knew I brought these for a reason. So at Exhibit 4, page 5, again, this is a formal issue paper issued by the State Board of Equalization. They wanted to ensure a uniform application of the regulation. And the importance of that is that we need to treat all cities and localities equally. We can't have one be provided a certain result and another a different result, even though the facts are substantially the same. The reg project was initially proposed under Regulation 1802, but as the project went forward, staff agreed that 1802 was not the proper place to address the buying companies. It was at 1699 for issuing permits. The staff proposed standards to the buying company which are much more stringent than what was ultimately adopted in the regulation. And at Exhibit 2, pages 10 and 11, and Exhibit 3 at page 3, they list the variety of different additional requirements that the staff was proposing. The project was well publicized. There were 28 submissions by interested parties, according to the SBE. And ultimately, the board adopted in February of 2002, the board adopted the buying company regulation as it exists today. One of the things that the staff wanted was not such a certain definition. Like in the buying company regulation, it talks about for the sole purpose of redirecting sales tax. That's where a buying company will not be recognized under the current regulation, where the sole purpose is. Now, staff was looking for something not quite as easy, if you will. They wanted something with principle, but that didn't really meet the problems that they were dealing with, which is the uncertainty. If we have principle or instead of sole, we're still going to have all of these fights. So they went with the sole, and they also defined what the sole reason for reallocating would be. And if you are involved in invoicing or involved in the transaction under 6099B, that's going to be enough to be treated not as solely set up to reallocate. So after this regulation was passed, this agreement between the City of Oakland and United came to light. And you'll see as I sort of describe what's going on, and it's been described in the exhibits that I've provided. The agreement is strikingly similar to the issue we have today. And it's not surprising because as a result of this Oakland United agreement, the State Board of Equalization looked at that agreement and was asked to reject the impact of it, the local allocation of it, and it didn't. The Board of Equalization was asked to repeal the buying company regulations in order to do that. It refused to do so. The Board of Equalization was asked to amend the buying company regulation because of this agreement, and it also refused to do so. What it did do was it instructed staff to go ahead and set up another regulation project to re-examine what was going on with the buying companies. So the Oakland United agreement. Jet fuel sales from a buying company and United were made pursuant to a master sales contract, much like here. The buying company was a subsidiary of United, much like here. The buying company was issued a seller's permit at its Oakland location, which was its only location. That office it was a 580 square foot office in Oakland manned by a single person. The airline issued monthly purchase orders to the buying company for estimated jet fuel needs pursuant to a master sales contract. And the monthly purchase orders were mandatory under the master sales agreement in order to have the title pass, much like the case here. Title to the jet fuel passed in California, as they have here. Much was made of the economic development agreement between United and Oakland, because much like here, there's an economic development agreement in that case where Oakland retained some of the additional sales tax revenue. United also received some of that sales tax revenue. There's a quote, and this was from, is that Exhibit 8, page 3, and I'll just read it to you. And this is, excuse me. Okay, so this is a quote from a spokesperson for United, and this, what I believe, is what sort of started this whole process of some of these other cities and localities saying this can't stand. It's actually, I'm sorry, I said page 3. It's at the top of page 4 where the quote starts, and I'll just read it. The beauty of the arrangement, United spokesman Jeff Green said, is that reallocation of the subsidiary is essentially paperwork. The company would open a one-person sales office at Oakland International Airport. The deal requires neither construction nor the transfer of a single drop of jet fuel into or out of Oakland. The deal would just consolidate purchasing the company does for the West Coast, work that can be handled by one additional employee. Although United has major operations in both San Francisco and Los Angeles, it is unlikely either city would offer the same business incentives. So there was some outrage about this from many of the parties, which is what led to the petitions of the city and county of San Francisco, as well as the county of San Mateo. In December of 2004, they filed a petition with the State Board of Equalization, using this United Oakland agreement as a basis for its petitions. And it asked the board to repeal the regulation retroactively. The board looked at it, considered it, and denied repealing it in March of 2005. That's when it ordered the Business Tax Committee, to consider some possible amendments. The staff did actually open a regulation project in April of 2005, and it held interested parties meetings in July and September of that year. And at Exhibit 11 is it's the Business Tax Committee discussion. And there, the Business Tax Committee sort of laid out the various proposals. There was SBE staff had its proposal, and the county of San Francisco and San Mateo had some alternatives. San Francisco and San Mateo wanted this repealed retroactively and effectively undoing the United Oakland Agreement. At the time, the State Board of Equalization staff's position was that applying this retroactively would be unfair. So their proposal was to apply it effective August 31, 2006, was at least the draft. However, this draft never got anywhere because the Business Tax Committee voted to abandon the regulation in November of 2005. There was a reason for that, and that reason was that the legislature stepped in. They knew what this issue was. They were aware of the Oakland United Agreement and how it impacts allocation of local sales tax. And they passed AB 451, which put an end to having jet fuel companies have a buying company in a single location. And the key to why this Oakland United deal works under the law is there's only one place of business. So there's a retailer with one place of business with the sales permit. There's no question that in that instance, it's a sales tax, and all of the local sales tax is allocated to where that place exists. And then on September 29th, 2005, the legislature passed AB 451. And the key point of that for this case is that they made it effective January 1, 2008. Our years at issue here are actually it's the periods, and there's the second, third, and fourth quarters of 2007. So this application of AB 451 doesn't apply until 2008. Now we should think, I want to talk about some prior legislation which actually didn't pass, which is kind of telling. And this is AB 2466. It's essentially identical to AB 451 as far as changing where local sales tax is allocated for jet fuel sales, where there is a single place of business. This was proposed, but it was vetoed by the governor. The part of the legislation said that we need a study by the state auditor to see what the impact is of changing this on the localities and their revenue and the agreements that they've entered into. The governor said we need more time to study the impact on local incentives and development agreements. And you can see that at Exhibit 14, page 5. That was the reason it was vetoed. Then 451 came along with an effective date of January 1, 2008 for that very reason, to allow the localities to give time for the legislature to discuss the impact, because these localities sort of rely a lot on the local sales tax, and the reason there was this delayed effective date was to make sure we're not pulling the rug out from under these localities who have entered into agreements. So the AB 451 resolves the buying company issue for jet fuel sales beginning in 2008. So the United and Oakland deal was allowed to go through, and until 2008, AB 451 ended it. Revenue and Taxation Code 7224 requires that each local jurisdiction has the right to have the law administered in a uniform manner. Oakland and United, their agreements were respected up until 2008 when the law changed. There's no basis to treat Fillmore any differently than Oakland. Now, I do want to, I'm kind of switching gears here now and going to the reallocation petition regulations. The panel has asked specifically about whether any parties demanded that a decision be rendered under 35056C4 within 6 months of the date the petition was received. So at the time that a petition was issued, we were under the regulation 1807B3, as the panel has noted. There's some slight differences in the language, but I'm just going to look to 1807B3. And it just says, if the allocation group does not issue a decision within 6 months of the date it receives a valid petition, then whoever's making this argument can demand that a decision be issued within 90 days, irrespective of the investigation. Now, how does this impact the latches argument was the question, and I'll say that these were not options for either Fillmore or the petitioners. And that's because the allocation group issued a decision within less than 6 months. And I'm just going to kind of go through now the process of what happened. So first we have the incorrect distribution of local petitions, which were filed by the petitioners, and that's at Exhibit P1 on March 28, 2008. On May 7th, 2008, there was a visit of the Fillmore office, apparently. That's at Exhibit A6. This is the scribbled note exhibit, which is I guess the auditor or whoever made the visit wrote down that they showed up in May 7th, 2008 at the Fillmore location. The door was locked. That note also says they called the landlord who'd never heard of retailer. And now we can look at Exhibit D, which kind of lays out what happened. And Exhibit Z kind of has all of the letters and correspondence. So March 28th, 2008, that's when the petition was filed. August 4th, 2008, the allocation group sent a letter to Fillmore stating the Fillmore office was not a valid sales office. The sales were negotiated in Houston and that they're reallocating the local sales tax. It was a use tax. You can appeal if you disagree by requesting an appeal conference. Fillmore responded August 28th, 2008, asking for a 30-day extension, which was granted. Then on October 3rd, they filed their response objecting to the allocation group's August 8th letter, also suggesting that an appeals conference may have been premature. October 29th, the allocation group sent a letter saying, we're moving the matter to the appeals section. And then followed up again with a letter on the 10th saying that you're going to appeals. The decision had already been made. So this question of latches and the delay was not at the very beginning. At the very beginning, they acted very promptly. In fact, too promptly, because I don't know how you could even do an investigation acting so quickly. But they seemed to rely only on the auditor who made this office visit in 2008 as a basis for saying that it was a use tax and that it was going to be reallocated. So after November 10th, 2008, everything went silent. There was nothing going on. No response, no correspondence from appeals. It was just told appeals will contact you. Been waiting for appeals. The next thing we have is a response to an information request on April 16th, 2012. And then by September 26th, the decision was rendered. The decision recommendation, that's at Exhibit A, pages 9 and 10, kind of detail what happened. And what happened was the regulations, the 1807 regulations, so Part A is just a bunch of definitions. Part B is review by the allocation group. And the section, it's B3, this is where no decision was made within 6 months. But a decision was made within 6 months, so there was no option for that. What happened was the allocation group kind of just didn't do anything. They just kicked it over to appeals. And there it sat for over 3 years before anything got done. And what I mean by anything got done is that any questions were even asked. So we have a period of over 3 years where there's no explanation that's reasonable for it. And the delay is certainly prejudicial, especially in this case where there's so many facts being asked about. CDTFA has noted that there's no evidence for X, Y, or Z. Think of what's happened over the 3 years. So Inspired Development, LLC, that in that course of time has gone away. The single person who ran Inspired Development passed away in 2012, I believe it was, and the retailer was acquired in a pretty large transaction. So documents get lost when time passes. When 3 years go by with nothing being done other than the auditor shows up at the door, it's locked. Okay, you know what? We can't allocate sales tax here. That's all of the evidence there was. And 2008, that office was closed down. So there really was nothing to find out in 2008. We're talking about periods of 2007. So the laches defense, and we've cited it, the department has cited cases as well. I don't think there's much of a disagreement about what it applies to. It's a defense where there's unreasonable delay, and as a result of the delay, there's prejudice. And I think that we clearly met that here. The delay was unreasonable. There was no reason for the allocation group to not do its job, which was to actually investigate the petition, gather evidence. They didn't do it. They said, this is just going to appeals. Why are we skipping over half of the regulation? I don't know. But then, some 3+ years later, I think somebody at CDTFA realized, hey, we messed this up. This has got to go back. And it did go back. And that cost a lot of time, which cost an inability to have all of the evidence, to get all of the evidence. Evidence deteriorates over time for the reasons I stated. People pass away, companies get acquired, document policies. Companies don't keep documents forever. Okay, so just looking at the agreed facts in this case, since the retailer was a buying company and it had only one California place of business, CDTFA properly issued the retailer a seller's permit because it's its only location. You can't issue a seller's permit to no location. You have to have one location. And why this whole arrangement works in a way that directs the local sales tax to where the retailer is located is because there's only one location, and that's where the seller's permit is at that location. And if you look at Regulation 1802A1, it's pretty plain. If a retailer has only one place of business in this state, all California retail sales of that retailer in which that place of business participates occurs at that place of business. So as a result, all the jet fuel sales made by a retailer through its only California place of business are subject to sales tax and the local portion allocated to that place of business in Fillmore. So now I'd like to get into Regulation 1620A2A. And so Fillmore's office was a place of business of the retailer that participated in the jet fuel transaction. Now, if we just look at the buying company regulation, one location, I think you can decide this case based on that alone. However, the CDTFA didn't look at the buying company regulation, did not mention it at all throughout all of this time, and instead is focused on Regulation 1620, and to argue that there was no place of business in Fillmore and that office didn't participate in these sales. And even if the 1699 buying company regulation doesn't dispose of this case, we can look right to this regulation and the facts of this case and conclude that the Fillmore office was a place of business. So just to address some of the contentions, one of the things that CDTFA is contending is that no place of business in Fillmore. And what they say is, hey, Inspired was in Fillmore because Inspired had the lease of the location. But that was Inspired. That's not the retailer, so it's not the retailer's location. And this just ignores agency principles that are pretty well established in California. The Inspired and the retailer had an agency agreement specifically to open an office and run an office out of Fillmore. So anything that Inspired did was as an agent of the retailer. And as a result of that, the retailer had a place of business where Inspired was. Now we can set that aside for the moment and say even if the law in California weren't clear that agents can act for their principal, Inspired leased the facility there was a lease that retailer entered into. There's an actual lease. So we don't really even need to rely on the notion of agency. And I want to just read one part of the 1620 regulation. It's specific about agents. Sales tax applies when the order for the property is sent by the purchaser, which is what has happened here, to any location, branch, office, outlet, or other place of business of the retailer in this state, or agent or representative operating out of or having any connection with such local branch, office, outlet, or other place of business. And the sale occurs in this state, which everyone agrees it did. So to ignore the agency is just incorrect. But again, it's sort of a who cares, because the retailer has its own lease. Now, they've talked about, that is, the CDTFA has tried to discredit this lease and say it's invalid and it shouldn't be considered. And they've sort of gone to some great lengths to try and show that by submitting a sample lease of another with the landlord and a different tenant. And the purpose of it is to say, hey, look, this lease had a provision that prohibited subleasing without written authorization. This is, well, I don't think you can really even consider that as evidence, but it doesn't matter. You don't need to, because even if there were a provision in the lease that prohibited subleasing without written consent, that doesn't make the lease void. It's voidable. It's voidable at the election of the landlord. And there's a case on this that's been cited hundreds of times. It's People v. Klopstock, Klopstock, 24 Cal 2nd, 897, pin site 901, 1944. The successive assignments, though made without the written consent of the lessor, were merely voidable, not void. There was no ipso facto termination of the lease by reason of the lessee's failure to obtain lessor's written consent to assignment. So this is kind of no reason to be chasing down this road, because there's no evidence in the case that the landlord voided the lease, because the landlord has to actually take action to void the lease. There's no evidence of that. Now, the last thing I'd like to address is the question of whether the retailer participated in the sales. And I think the evidence is overwhelmingly yes, the retailer participated in the sales. They have the master sales agreement. Under that master sales agreement, you could not transfer title to the jet fuel without purchase orders and authorizations. And you can look to the master sales agreement itself at Exhibit A5, page 8. Negotiations and execution of the master service agreement was done in the Fillmore office. Now, a lot has been made of this with the declarations signed under penalty of perjury, that there was the execution and negotiation of the master service agreement in Fillmore. But that's cumulative evidence. It helps to show that there was participation at the Fillmore office, because that happened, but it's not essential. What's essential is the purchase orders, the authorizations, all going into the Fillmore office. The person working at the Fillmore office, writing the purchase orders, receiving the purchase orders. That is where the participation is shown. So it really doesn't make much of a difference whether the MSA itself was negotiated or executed at the Fillmore location, even though the undisputed evidence shows it was. There's testimony under penalty of perjury signed that says so. The CDTFA wants to discount that because they believe the people who signed it, who are employees of Ryan, cannot be honest because they have some sort of financial stake, and there's no evidence that the employees of Ryan have a financial stake in the outcome. And I don't know if it's very reasonable to say if someone has a financial stake in the outcome, we can't have their testimony. We would have a lot less declarations if that were the case in cases that are before you as well as in the court. In the courts, declarations are often used and are valid evidence signed under penalty of perjury, and very often it's an employee of a company giving it to provide evidence when there's otherwise none to be found because so much time has gone by. We sort of had to go to the declaration because that declarations are used a lot when evidence is missing to try and fill in the gaps. So in closing, there's just I wanted to provide the panel with a few ways I believe they could conclude here to find that no reallocation is proper. One is the latches, unreasonable delay, and prejudicial. I don't think there's any dispute that this delay was unreasonable. It doesn't matter that the petitioners were not involved, were not at fault for the delay. It's unreasonable delay and prejudice. A second, and these are all independent ways the panel can go to decide this. You could just say latches, case over, I don't even need to get into any of the other stuff. The second one is another simple one, which is to say there's insufficient evidence that sales occurred in Houston to apply use tax. We have quite a bit of evidence about what's gone on at the Fillmore office, but the evidence is very light that anything happened in Houston to apply the sales tax. A third independent way to conclude that there should be no reallocation is that you cannot retroactively revoke the retailer's seller's permit, because having the seller's permit and one location means that's where the sales are allocated. So the CDTFA needs to retroactively revoke the retailer's seller's permit for any of their positions to work. Fourth, the buying company regulations, the Oakland United deal, and AB 451 show a clear intent by the legislature as well as the State Board of Equalization making the regulations that these arrangements are to be respected until January 1, 2008. And fifth and finally, Fillmore office was a place of business of retailer, and that it did participate in the jet fuel sales. And this is kind of where all of this CDTFA's argument lies, is in my fifth point. The fifth way you could find for reallocation is it was a place of business. The evidence shows it was a place of business. The evidence shows that the retailer participated in the jet fuel sales transactions, but there's no evidence that it did not. And that's all I have.
Thank you, Mr. Cataldo. I do have some questions for you, and they are lengthy, so please be patient with me.
Okay.
First, I don't believe there's any dispute among the parties that retailer is a buying company, and if petitioners and CDTFA feel differently, please let me know during your presentation. So having said that, is it appellant's contention that because it's a buying company, it's automatically entitled to a seller's permit?
Because, well, let's look at the regulation. Mm-hmm. Yeah, I'm just going to pull it up right now. So here's the important thing. That's why I read this whole regulation. I did not want to, but I thought it was important. We have to look at what is the definition of a buying company? What is it doing? It's performing administrative functions, including acquiring goods and services. That's what was done here. That's what the retailer did here. And then there's a lot of words about when it is and when it is not going to be respected. Those words are the sole purpose to redirect. Now, if the sole purpose of the buying company is not to redirect the local sales tax, it shall be issued a seller's permit and shall be regarded as a seller of tangible personal property it sells or leases. Again, the retailer was acquiring goods at the location in Fillmore. The United Oakland deal discussed this almost exact situation. So because there's only one place of business, yes, I believe under 1699, under the buying company right, in our case, if you meet this regulation, because this was being done at Fillmore, that, yeah, the sales have to be allocated to Fillmore, the only place of business.
Okay, so yes, you agree it first needs to be found a place of business.
Well, yes. Like, for example, if there's a buying company in some far remote place that does all this stuff, it's not in California. There's no seller's permit that's going to be issued.
Okay, just wanted to clarify. Thank you. Okay. As for your latches argument, is it, just to clarify, is it appellant's position that petitioners caused any delay?
Well, the petitioners filed a petition and then did nothing else. They didn't actively prosecute their claims. They were coming to the board to say, hey, we have a problem. We have a claim. And now we filed our petition and then did nothing. They let the CDTFA kind of run with it, but they ran a really strong burst for a little bit and then stopped. And I have to look and say, well, 3 years in, 3 years go by. Did petitioners do anything to say, hey, what's going on with our claim that we have? There was nothing. So to the extent that they sat on their hands and did nothing, yes, they have some fault in this.
Okay, so on March
but it's not required. I'm sorry. I didn't mean to
I'm sorry.
interrupt.
Go ahead.
It's not. I don't think it's latches requires that. It's unreasonable delay and prejudice. Those are the two things. It's not someone got a benefit or didn't get a benefit. Unreasonable delay, which I think the record shows clearly there was, and prejudice, which is, if you find that, hey, all of this evidence that CDTFA is kind of picking at and complaining about not showing what it really shows, and therefore it's a use tax, and it's use tax to Houston, there's prejudice there. We would have had the opportunity to look into and get the evidence if more than 3 years didn't just evaporate.
To follow up on that, so on March 29, 2008, CDTFA received petitioner's petition, and then on August 4, 2008, CDTFA noticed appellant that it intended to reallocate. As to that, I don't understand your position as to how petitioners caused any delay.
How petitioners caused any
Correct.
delay. Okay, so there was. Let me go to the. I want to make sure I'm answering your question.
Thank you.
So, August 28th, 2008, they requested an extension. I'm sorry.
No,
can you
that
repeat
would-
again what?
So, if I'm correct in my timeline, in March of 2008, CDTFA received petitioner's petition,
Right.
and they were, taken by CDTFA. I'm just going to refer to BOE as CDTFA. So
Okay.
that's
fine.
Yeah. And then in August 4th, 2008, CDTFA noticed appellant that it intended to reallocate, well within the timeline for it to issue its decision. And so at that point, I'm kind of unsure as to how petitioners caused a delay. If they gave their petition, CDTFA notified appellant, and then appellant filed on October 3rd, 2008, its petition for that against that notification.
Right. So the petitioner in these reallocation cases, other than file your petition, there's no obligation for them to do anything. So it is the CDTFA's responsibility to run it through the regulations. The allocation group is supposed to look at it. The only way I can point to the petitioners and say it's your fault is not through that period, but from the period of November 2008 all the way through 2012. The years that had gone by. And this is the petitioner's claims. And you didn't say anything. You didn't ask, hey, how's our claim going? Should we be worried about it? So to the extent we can point the finger at petitioner, it's really limited to that doing nothing in
Okay.
that period of time.
All right. Thank you very much. Appellant asserts that the 4-year delay caused unreasonable and prejudicial because business operations in Fillmore had since closed, and many documents are no longer available and witness testing memories had waned. Is that correct?
Yes.
Okay. According to the record, CDTFA received petitioners' petitions on March 29th, 2008, and then just over 4 months later, on August 4th, 2008, CDTFA notified appellant that it intended to reallocate the local tax at issue, correct?
Let's check Exhibit D, because intended, does it say intended? Sorry. Okay. So I'm looking at the August 4th, 2008 letter. Based on information in our possession, and this is August 4th, it's from the State Board of Equalization to Fillmore. Based on the information in our possession, it is the board's position that the registered location is not a valid sales office. It is our opinion that the taxpayers' sales are negotiated in Houston, therefore no local tax should is due. I'm reading it. The city of Fillmore. Accordingly, based on our date of knowledge, March 27, 2008, and we propose to reallocate the local tax. If you do not agree with our position, you may appeal this decision by requesting an appeals conference. So that's what was sent to
So I misspoke, not intended, but proposed.
Yes,
Okay.
proposed.
To which then appellant did file a petition against that for that of that notification on October 3rd, 2008. In response.
Yes. They were a little confused when they filed it. Like, why are you skipping through this whole process? Shouldn't we be looking at it at the allocation level? Why are you just suddenly going to appeals? But they did. They responded to it and said they didn't agree in their letter. And then they got two letters, got a letter back on the 29th saying, no, appeals. Oh, yeah.
Okay, Mr. Cataldo, I'm going to stop you. I have learned this case inside and out, so I know all the letters, notifications, everything. But I'm going to keep continuing with my latches questions. When appellant received that August 4th, 2008 notifications, what steps did appellant take to obtain documentation, testimony, et cetera, supporting its position at that time?
At that time, they looked at it and they said, okay, well, this is the United Oakland deal. This is what we have to do in order for this to work. We have all of the documents that we need. And they did have all the documents that they need, and it's their position to this day, all of the documents that they needed, they have. But the CDTFA's position is that these documents are not good enough and that we need more information. And it is, if that more information is what causes Fillmore to lose this, then that would be prejudicial.
I understood the argument to be that because there was a 4-year delay, you were unable to get the documents and everything, but now you're saying you had it in appellant had it in 2008. So can you please clarify?
So we had the documents that are actually essential to deciding the case, like the agreements, the agency agreement, the purchase agreement. But the information and details that we didn't have, if you look at a lot of the information requests after, like in 2013 and 14, once they actually started picking up the case, and the details and information, which frankly, that information is sort of irrelevant to the case. It doesn't change it, but they're asking for it. And if they're concluding all of this info that you don't have, we're going to, even though it's our view that this info is not relevant, if they say it is, and you're going to decide, or they're going to decide, well, based on this lack of information, you lose, well, then we maybe would have been able to get that information 3.5 years earlier.
To which I then ask you if you had the documentation in 2008 and submitted it to, and I'm going to say you, I know you are not the representative at the time. If you had given CDTFA that documentation in 2008, CDTFA probably, and you can address this, had been able to, in 2008, 2009, looked at the documentation, and then been able to provide those questions for additional documentation. So, again, this lapse in time of appellant giving CDTFA the documentation when it was notified in 2008 of this potential reallocation, I'm having a hard time wrapping my head around. Mm-hmm. So if you could please clarify.
Yes. And I think it was just the tone of these letters. One paragraph, very little investigation, and just the definitive, we've decided that it's going to get reallocated, and you can appeal. Go to the appeals conference. So if you're the appellant and you're looking at this and you're reading the correspondence, they said, hey, why are you jumping the gun? They even brought it up, you're jumping the gun, but there was no response to that. It was just, you'll be contacted. You will be contacted by the appeals division, is what the letter said. In the letter before that Fillmore sent, they said, hey, we've got this stuff, we're gathering this stuff, and then their response was, you'll be contacted. Does that answer your question? Because I feel like maybe I didn't answer it.
Okay,
the November 10th, 2008 letter, they will notify you of a time and place of the conference. They didn't say, can you give us the information?
Well, appellant did, sorry to interrupt, appellant did indicate in it's an October 3rd, 2000 petition that it was in, quote unquote, in the process of obtaining copies of documentation, and that it expected to provide that information within 30 days. And then there was a 3.5-year lapse between that letter and when appellant gave the documentation.
Right. So let's, because that's interesting. We expect within 30 days to give you this information. We're gathering it, whatnot. But then what happened was, within less than 30 days, we got the letter from the State Board of Equalization. That's the October 29th letter. We feel this issue can be best addressed at the next level of appeals process. Therefore, we're forwarding your appeal to our appeals section. You'll be contacted regarding the scheduling of an appeals conference at a later date. No, can you provide us the information? No questions, none of that. And then on the 10th, they kind of say the same thing. This is to acknowledge your appeal of our proposed reallocation. You didn't give us any new information. Your appeal didn't present any new information. I mean, this is on the 10th. Like, they haven't even asked for the info, and they're already saying, we decided, and you can go to appeals. Like, honestly, it seemed like they just didn't want to do this. Maybe they mentioned staffing in the DNR. I don't know what it is. What I do know is, at least from the documents I'm looking at, the allocation group didn't really do any work on this, and it got sent to appeals. And then eventually someone at appeals looked at it and said, hey, wait a minute, we forgot to go through the whole process that the allocation group's supposed to do. Let's kick it back down to them. And that was 3+ years.
And during that time, appellant didn't find it. Appellant's been in this position more than once. They've had such cases. And so I'm just kind of curious, like, why they just wouldn't submit the documentation so that they could have it.
Oh, so I'm speculating now because there's nothing in the record about this. But if it were me and I'm looking at it and they say, we've already decided at the allocation group, and we send a letter saying, wait, what about the rules? What about the regulations? What about the allocation group performing an investigation of any kind? But no, they already decided, and you'll be notified. We're sending you to appeals. Okay. Who's notifying me? Where do I send it to? Normally, in most cases, I know this is a reallocation case, it's very unique, but typically when you're representing a taxpayer, you're at an audit, you get IDRs, and then you answer the IDRs. And if you don't, in a timely fashion, the Department of Revenue, whoever you're dealing with, CDTFA, FTB, they don't just disappear for 3 years and not say, hey, where are your responses? They say, where are your responses? And that didn't happen here. So that's a long-winded way of trying to answer your question.
Okay, no, I appreciate it. No, but it's okay. It is indicated in the record that this matter was one of 8 CDTFA appeals to which appellant was concurrently a party, and appellant, having participated with CDTFA in deciding the prioritization of the appeals, gave several other appeals higher priority because CDTFA had not distributed some of that amount that were reported to appellants pending the outcome of appeals. What is appellant's position on this, and especially in the context of latches?
So I'm not aware of anything in the record where appellant said, hey, just ignore this case. I'm not aware of anything. They say in the DNR, they say there was some scheduling, but I don't see anything. I'm not aware of any sort of document or letter saying we're going to backburn this case.
Okay, thank you. And then one more question with regards to latches. I understand the unreasonable delay, but in general, latches is defined as the neglect or failure of a plaintiff to assert a right for such a period of time that results in prejudice to defendant, requiring that the plaintiff's cause of action would be barred in equity. Would you agree with that?
Well, not in this case, because we don't have a plaintiff in this case. If that's what you're getting at, like you have to be a plaintiff for latches to apply, I don't think that's the case. I think it can be applied against a government agency. You know, one of the things, and I was looking at this case, let me just pull it up. Yeah, it's cited that Brown versus State Personnel Board. Mm-hmm. So they were talking about latches in the context of a local administrative agency exercising quasi-judicial functions. And one of the things they said is unreasonable delays as a matter of law when there's no statute of limitations. And you think about the reallocation regulations, other than what the panel had pointed out earlier about, hey, you know what, you have a right to, say, issue a decision now if it's within 90 days. Well, once that's done and that opportunity is over, there's no statute of limitations. We could sit here forever. There's nothing to compel the board to act. So, and in those cases, and this was that Brown case at page 1160. That's kind of like where you would apply latches. Like normally, you have the statute of limitations that's supposed to protect you from these long delays. Like, what's the policy behind a statute of limitations? It's evidence disappears over time. Where there's no statute of limitations is where latches is particularly applicable, and that does apply here.
I've read the case, but if you could please remind me, was the government agency or the agency not asserting a right in that case?
Were they not asserting a right?
Were they asserting a right? Because my question is that the reason why I'm trying to, CDTFA, in all intents and purposes, was not a party to this reallocation. They are pretty much a first trier of fact as to whether the reallocation. They aren't receiving the money. They aren't. It's not a NOD. It's just CDTFA is deciding who gets the money. So therefore it's not asserting a right to the money. Can you expand on that, your position?
Well, I thought I saw something that said that they were a party in the reg. But yeah, I mean, I think, yeah. Okay, so this is, I'm just going to refer to 35056-9, A9. Party means the jurisdiction filing a petition for redistribution, any notified jurisdiction, and the assigned section of CDTFA. So I think at least under this regulation, they're a party.
Okay, thank you very much.
You're welcome.
Now we're on to place of business.
Oh, man, more for me?
Oh, you have a lot.
Oh, boy.
Like
All
I
right.
said, I went through this file inside and out.
Excellent. I appreciate it.
Of course. Let's see. The meeting regarding the master sale agreement, which I'll refer to henceforth as MSA, took place in late September before the October 1st sublease between retailer and Inspired. Is it appellant's contention that the Fillmore office was retailer's place of business when that meeting took place?
Yes.
And can you expand on how that is?
Agency.
So is it appellant's contention that an agency's place of business is transmuted into the principal's place of business?
When the agency agreement is explicit and the whole purpose of the agreement is to set up a place, and that is the place, then yes. And that's the case here. The entire purpose of the agency agreement was to set up the office. So Inspired did that. And while they were there, they were acting as their agent, and that was their place of business. And I will point out that I don't think that is, it's like I said, it's cumulative, that evidence, as far as participation in the sales, the invoicing, the purchase orders, the authorizations. That is enough for participation in the orders. Participation in any way.
Well, we'll get to participation of sales. Believe me, I got it all figured out. So do you have legal authority as to the 2006 agency agreement transmuting agency's place of business to principal by just merely having that agreement?
Just general agency principles. I mean, I don't have it right now, but I don't think it would be hard to find. I mean, you could look at the civil code. I don't have it right now. I don't, so I couldn't point it to you. But, I mean, the civil code is full of definitions about what agency is. Contractual rights. So if we look at the actual contract, the agency agreement's a contract. If we look at the contract, what does it say? The agent acts for the principal. Like, they're doing it as if the principal's doing it itself.
Okay, thank you.
I mean, we could look at, in a tax case, we have the Borders case
Right,
that's
yes.
been mentioned, and Scripto, if we want to go all the way back to the Supreme Court, talking about like the distinction between an independent contractor, employee for tax purposes, it's irrelevant.
Okay, thank you. I just, again, a lot of these questions are just so I can wrap my head around it when we write the opinion.
Happy to have the questions.
Thank you. Does appellant have any evidence demonstrating that retailer ever intended itself, not through its agency, or that intended or that it ever did physically use the Fillmore office? Like, did it have employees that weren't an agent work out of it? Did it ever, retailer itself, not agency, make use of the office and have external indications tending to show the office as its place of business, like external signage, advertising, websites, any of that?
So my answer is, again, agency, and I'll explain. The people working for Inspired Development who were there at the office were acting as agents of retailer. So the fact that there was no employee of retailer there, if that is even a fact, I don't know for sure. There's nothing in the record, but it doesn't matter. That place was operated under an agency agreement, and people who were fulfilling the obligations were in that office. No signage. We have to think about this transaction. This is a captive jet fuel purchasing company. So it's not like we're looking for foot traffic to sell jet fuel. So the notion that the signage and business cards or whatever, that I don't think that is relevant to this case.
Okay. Thank you very much. And now participations in the sales. We're almost, I know. Okay. I understand that it is appellant's contention that the MSA was negotiated at the Fillmore office. There's been a couple dates mentioned, September 27th, September 28th. Can you please clarify appellant's, which date appellant is contending?
Which date that
The meeting took place.
I'm just looking for the, pardon me, I'm looking for the declaration because it says it in there.
Yep, take your time, no worries.
I believe it's the 28th.
28th, thank you. Can you please expand on what exactly was negotiated at the Fillmore office? And any evidence that a real negotiation took place during that meeting?
I don't know. I only have what you have as far as the evidence. I will say that I don't think let's look at the law again. for a second. Single place of business.
Get closer, please.
Oh, okay. Single place of business. So if there's a single place of business, it goes there. It's allocated there. Like, we don't need to go to this question of, there's two competing. Which one do we go to? Well, where was the principal sales negotiated? That isn't a thing that we even need to deal with because there's not two. There's just one. What happened at that office when they executed these agreements, and what are these declarations really saying about what happened there? I mean, I don't know. I read the declarations, and just like you can read them, and that's kind of all I can see from it. But what I can say is that it's really, like, again, a cumulative evidence of participation in the sale.
Speaking of the declarations, I did read them, and the declarants each say that the meeting took place on September 28th. Yet, according to the travel documentation provided, Mr. Kersey and Mr. Jones each checked out of their hotel on September 27th and the day before, and Mr. Logo flew out of LAX, which is approximately 60 miles from the city of Fillmore, the morning of September 28th at 10:55 a.m. I was hoping you could please help me understand the discrepancy between the statements made in the declarations and the declarants' travel itineraries.
I'm going to admit I didn't look at that one.
Yeah, I told you I looked at everything.
Let me. I really don't have any comment on it, just because I have to find it. Let me see. Where is the travel itinerary? All right. There it is. Sorry. Okay, I'm looking at the travel itinerary now. Check in, check out. This is a hotel, I think. Expedia. 28th, check. I'm looking at. Okay, I'm blind. Where are my glasses? There we go. Zoom it. Check in 26th, check out 27th. Okay, I see what you're saying. I don't know. I don't know.
Thank you. Let's see.
I mean, I'm looking at one that says check out the 28th. I mean, there's one that says the 27th, but then now there's one that says the 28th.
Would that be Mr. Logo?
That's Mr. Logo, yes.
Thank you. And I understand your appellant's position is that the negotiations isn't really relevant. However, I still have a couple more questions about it, please.
Okay.
So I was looking at the MSA, and it is all typed except for the gallon amounts, which appellant's position is that it was negotiated at this meeting. So I'm just having a hard time wrapping my head around why all but just the gallon amounts would be typed up if it was negotiated at the meeting.
Well, I think it's because they don't know the exact amount they're going to have. It's just requirements. And I mean, if you look at the not agency agreement, but the master sales agreement.
That's Exhibit A5, correct?
A5. So, I mean, it talks about, like, we don't know the specific quantity. Like, okay, so let's start with, it's A5, page 3. Let's look at number 2. Quantity and limits. Buyer and seller agree that although the specific quantity of aviation fuel, equipment, supplies, and other related items that buyer is under obligation to purchase is not fixed by this contract, buyer is obligated to make purchases of at least 2.5 million to 15 million gallons. So that's what they were obligated to do. But it recognized the specific quantity was not fixed by the contract. Yeah, then 6, when known or capable of estimation. So, I mean, I think there was just an understanding that they didn't know exactly the amount, but that there was a procedure in place for placing the orders.
Okay, so to follow up on that, are you saying the only things that were negotiated or talked about at the meeting were the gallon amounts?
Well, no, I'm not saying that. Maybe it is, maybe it's not. I don't think the evidence limits it. It could have been. I mean, the declaration are the only things in evidence about what happened there.
Okay. Thank you. Before I continue with the rest of my questions, I want to acknowledge that the parties disagree whether the documentation appellant provided were actual purchase orders and authorizations to release inventory. Having said that, OTA will use those terms when discussing the documentation for ease of reference. Okay. Regarding the purchase orders, appellant contends that the purchase orders from customer were regularly and systematically reviewed, processed, and approved at the Fillmore office, and that the review of the purchase orders include checking them against the MSA, authorizing the release of fuel only if the orders were consistent with the terms of the MSA. Do I have that correctly?
I think so.
Okay. So I've reviewed the purchase orders, and the range in each purchase order is inconsistent with the maximum and minimum gallon amounts delineated in the MSA. And Ms. Cooperman said that in her declaration that she reviewed orders, ensured the orders were within the prescribed requirements set forth by the MSA. And if a purchase order was not correct, it was her duty to reject the order and notify customers as to the basics of the rejection. Is there any evidence that Ms. Cooperman rejected an incorrect purchase order?
There is no evidence of that. And, I don't mean to go back to latches now, but
Okay.
it's the perfect, example of where it would matter. There's no evidence now of that.
Okay, yeah, thank you. The purchase also orders indicate that retailer will sell aviation fuel to the customer pursuant to this order. But there's a wide range. So could you please help me understand, based on that, how retailer would know how much fuel to sell to customer?
How retailer would know how much fuel to sell to customer.
Yeah, by looking at that purchase order, retailer is going to have to provide customer fuel at different locations, at different airports, and different amounts of gallons, different days. So, based on that purchase order, which appellant is contending is a purchase order, can you please help me understand how the retailer would know the amounts and the locations based on that purchase order?
I think the amounts, the specific amounts, I don't know because there's no evidence in the record as to how the specific amounts were determined.
Okay, thank you. Give me a minute, please. All right, I'm going to just go into invoices, and this will...
I'm sorry, I didn't hear.
I'm going to move on to invoices. Thank you. It appears from the evidence that the invoices were set subsequent to the month the fuel was sold. For example, invoice dated May 4, 2007 is denoted as the monthly billing for the sale of fuel in April 2007. Is it appellant's contention that building activity done after the sale qualifies as participation in the sale?
Yes.
Okay, and can you please expand on that?
Participation in the transaction in any way. So that's one of the things that I think is part of participating in the transaction. It's just one. It's not the only one. It doesn't carry the whole day. I mean, there's other things as well, but that would be, I think, included.
Perfect, thank you. And that concludes my questions. We'll do questions with the panel, and then we'll give the stenographer a break. Would that work? Yes. Okay, so Judge Wong, do you have any questions?
I do have, excuse me, I do have a few questions for appellant. Mostly regarding the buying company regulation in 1699, at the time H, right? So
Correct.
Part H. But before that, could you give me some background on Fillmore? Where is it located? Like, just
It's in Ventura County.
okay.
I'm not sure, like, other than it's in Ventura County, I don't know. I could check Wikipedia and see what it says. I mean, that's kind of what I've done. So, there's nothing about it that jumps out at me as particularly, like, different or relevant for this case, but.
Yeah, I'm just wondering what its relation to buying and selling jet fuel is.
Oh, you kind of got to go back to the United Oakland Agreement and how that was born out of the adoption of the regulation in the first place. And the back and forth, what should the regulation say, what should it not say? There were, cities and counties saying this is too loose. There were others saying, hey, the localities should be able to negotiate these economic development agreements. So it's like a part of the economic development agreement was having an office in Fillmore. The connection between Fillmore and the jet fuel, like there's no jet fuel passed through Fillmore. The jet fuel went, whether it went or it was in the storage tanks in the airport. But, I mean, if you look at the regulation and the United Oakland deal, the board's reaction to that, and then AB 451, you don't need to have a connection with the locality for the jet fuel.
Was one of the reasons why retailer was formed, was it for the purpose of redirecting local taxes, like one of the purposes?
So there's stated purpose of, so there was a sales tax refund claims, and this was in the briefing. That was one of the purposes for the setup. There was an economic development agreement. So part of the reason was this economic development agreement. That's permissible. I mean, the legislature recognized, if you look in the exhibits about in AB 451, as well as the prior legislation that was vetoed, everyone there in the descriptions, these agreements are legal. The localities are allowed to enter into economic development agreements, and they can do it how they want to do it, and they can compensate how they want to. They're independent in that way, and the CDTFA can't go in. There's no state law prohibiting it. CDTFA can't prohibit it, and they can't do policies that would influence or mess with the contracts that these localities enter into.
Was retailers' sole purpose redirecting local sales taxes?
No.
Okay.
No.
What were the other purposes it was formed for?
To facilitate the refund of sales taxes on jet fuel that were ultimately used in international travel. So before, and I think they're still doing this actually, even though this whole reallocation single place of business has been changed because of AB 451. They're still doing this because certain jet fuel used in international travel is not taxable, but having a single entity file all the returns, they can get their refunds back versus going to the supplier, all the different suppliers, and having to do it that way.
Did retailer cease to exist or close down shortly after the law was changed that you're referring to? I'm specifically referring to Regulation 1802. At the time, I think it's B6B, which changed where the sale of jet fuel takes place, and it became effective like January 1st, 2008. My understanding is that retailer stopped doing business in Fillmore shortly after that, or...
That is correct. And you know, I kind of want to follow up on the last question.
Sure.
Because you were asking about the sole.
Yeah.
And it's in the regulation itself. The buying company is not formed for the sole purpose of redirecting local sales tax if it has one or more of the following elements. And I'm going to skip that markup. That's one of them, but that's not relevant in this case. The other is issues an invoice or otherwise accounts for the transaction. So, not a lot has to be done for it to not to be the sole purpose. Now, we've done that, so it's not sole purpose, but there is other purposes besides redirecting that was here. Nevertheless, I understand where you would say, hey, you know what, you can't come here and say that, and I don't even think redirecting is the right word. It's just this is where it's allocated. And you located in Fillmore, if part of the reason and part of the incentive of relocating or locating in Fillmore was the sales tax allocation deal, that's permissible. And I think by the fact that they closed up shop in 2008, January 1, kind of tells you it's significant, but not sole.
Pretty clever. But so my other question is, it goes to Judge Ridenour's question regarding negotiations. So my understanding is retailer and its customer, its main customer, is it the only customer it had?
Yes. Well, pretty much. I mean, there was affiliates as well, but for the most part, it was just the airline and its affiliates. Those are the only.
But they share common ownership. Is that correct? Like,
yes. Yeah, it's captive. Like, the airline owned the retailer,
okay.
100%.
And I know CDTFA, in their decision or supplemental, or maybe even both, they mentioned this, but like, in what sense was it a negotiation if both parties are related? In what sense is it a negotiation?
Yeah, that's a good question. Like in negotiation, as far as like hemming and hawing back and forth, offer, counter offer. I don't think the word negotiation requires that level of counter offer. Like, and I thought about this scenario. Like, I always go to the hardware store, and you're going to go buy a hammer as the simplest application of sales tax you could possibly come up with. And I go in to buy a hammer, and the hammer costs, I don't know, $12. I pull it off the shelf. I'm not hemming and hawing. I'm not saying, how about $9? I'm just paying it. That's kind of like the negotiation of what's happening and why sales tax is allocated to that place.
That's all the questions I had for now. Thanks for your presentation.
I would like to kind of follow up on one thing that you mentioned, because you did mention that the setup was clever, and it was. Fillmore wasn't the one who set it up. I mean, Oakland United kind of did this, and then it came to light, and then the legislature sort of stopped it. So it's like this has been done before, and Fillmore and I don't know how many other cities said, okay, well, if Oakland's going to get this and X city is going to be able to do this, we should be able to do it too. And I think the law requires they are treated equally. So I just wanted to put that in there.
Thank you.
Thank you.
Thank you. Judge Brown, did you have any questions?
I do not have any questions. Thank you.
Right. It is 2:45. We're going to take a 5-minute recess. We're off the record. And thank you. Oh, you know what? We'll have 10. Thank you. 10-minute break. Off the record. Welcome back. We're back on the record. Petitioners, you have 20 minutes. When you're ready, Ms. Varney, please begin your presentation.
Thank you very much. In an effort to be sensitive to time and also not to be overly repetitive in terms of a lot of information that's already been exchanged and questions you asked and so forth, and things that are already submitted in the record on our briefs, I'm going to kind of touch on some of the points that were more important to me as brought forward by Mr. Cataldo. First and foremost, I wanted to bring up the fact that the CDTFA or SBE, they're contracted by the local jurisdictions here in California to collect and remit the local tax on their behalf and then distribute it and fund it back to them. So in that regard, they are constantly reviewing and monitoring and so forth on behalf of the jurisdictions because they are paid to do so by those. Our role is to kind of backstop that process in that we also monitor and look to make sure that based on our knowledge of laws and regulations that the local tax is being allocated to the proper jurisdiction. One of the important points, I think, also is to note that when a business applies for a seller's permit, the information that may be provided at that time may not be fully complete in the sense that it may say that it's going to be sales, but in terms of the greater details in terms of that office's operations or so forth. So when a seller's permit is registered and issued by the State Board of Equalization and then is by virtue of the address that is registered, they issue the tax area code that then tells them where they're going to distribute the local tax to once the taxpayer files the return. So the address becomes relevant there in terms of how the CDTFA knows where to fund that local tax based on the tax return. So one of the things, one of the comments that Mr. Cataldo made is referencing to revoking the seller's permit. This case was not about revoking a seller's permit. It was more about determining what the proper place of sale was. Is that the city of Fillmore? Was it registered properly? Is that where the local tax belongs? Or should the seller's permit be registered to another location, in this case potentially their out-of-state headquarters? So Muni Services, on behalf of the petitioners, we first became aware of the offices in the city of Fillmore starting in 2006 and filed one case back in 2006 on behalf of a retailer, and then subsequently filed on 7 other retailers in 2008, of which this case is relevant to one of them. As was discussed, many of these cases were going through the process simultaneously, so a lot of the investigation and work that was being done not only by ourselves on behalf of the petitioners, but also CDTFA was a lot of overlapping of case investigations, etc. We had visited Fillmore in February of 2008 prior to our filing our petition, and also done a thorough investigation of the facts that we could obtain in terms of where the point of sale would be related to the sales of jet fuel involved in this case. One of the other points I wanted to touch on was the issue of the timing of the letters that were brought forward and that somewhat translated into the appellant's discussions about latches is the fact that there was also a change, a regulatory change on 1807 that changed the different levels of appeal And so I think what occurred at that time was when they initiated the original letter advising the city of their proposed reallocation in this action, they realized that they needed to step back and run it through the appeals process, and that subsequently ended up with a separate decision to us and ultimately the DNR. I don't think that the appellant can in any way make comment as to what we were doing or not doing on behalf of our petitioners during the time that this case was under investigation by the CDTFA. There's no way he would know what actions we may or may not have been taken in terms of trying to be involved in resolving the issue, as we do every day on behalf of all of our clients and all the petitions that we file. A couple of the other things is that the arguments being made in this case are repetitive of arguments made in the other cases of which the appellant was denied. And the key dispute in this case was whether or not the office in the city of Fillmore was a place of business of the retailer, and whether or not actual sales negotiation occurred at that. And without belaboring that, we disagree that either of those things apply in this case for all of the, regulations in terms of place of sale. And I apologize, I'm mumbling probably a little bit here. But for a sales office to be considered a place of business based on annotation 710-0013,
Give me that again, the annotation.
710.0013 states that for a field sales office to be considered as a place of business for the purposes of the Bradley Burns, the retailer must have proprietary interest in that office space. And in this case, I think that we have discussed and determined that the retailer did not have proprietary interest in that office space at the time that they claimed that the MSA was negotiated in September, prior to the lease to the retailer from Inspired occurred. Also, using that office on occasion for the purposes that they claim still is somewhat unsubstantiated. The documentation as presented in this case does not actually, is not an actual purchase order, and it doesn't actually identify the specific number of gallons that are going to be purchased, nor do their claim of the invoices that are supposedly generated at that office do not identify specific amounts that were purchased and utilized at the different airport locations during the periods in question. Also, at the appeals conference, the prior conference that had been held, statements were made by the retailer that the negotiation of that MSA was merely just to, apologize, let me find my note. I'm sorry. That the actual terms of the MSA were not being, that the gentleman that he delegated the authority to was only to execute the document at that time. It did not authorize them to actually determine the terms of the MSA. And as we've already discussed, the supposed or the alleged purchase orders, again, all of them were the same. They noted the same minimum and maximum, which we've already established did not match the terms in the MSA, as did the purported invoices do not specify how many gallons were actually utilized, and therefore how could that be an invoice when you aren't invoicing for an actual amount. Also, I wanted to state that we don't have any disagreement with the issue of the buying company, and so I won't be addressing anything further on that issue in this. And that we are in agreement with the CDTFA decision in the supplemental, the DNR and the supplemental DNR, that it is a use tax, and that for those contracts that were and purchases in excess of the $500,000 limit, that those allocations would go directly to the petitioning jurisdictions, with the balances being allocated through the countywide pool. So I believe that's all I have right now.
Thank you very much. To expand on your argument regarding execution versus negotiation, can you please expand as to the authorization to execute an agreement would not be the same as to allow them to negotiate an agreement?
And again, I will speak to that only in the sense of reiterating the statements that were made by the retailer at the. So Mr. Meisner, who was an officer or manager of the retailer, said that he delegated his authority to sign the agreement. And in this authorization, he delegated them to execute it, but gave them no authority to negotiate the terms. So that was the basis of that comment.
Thank you. That's all the questions I have for now.
Okay.
Mr. Wong, Judge Wong, do you have any questions?
I do not. Thank you.
Thank you.
Judge Brown?
I do not have any questions right now. Thank you.
Thank you.
Thank you. And with that, we will move over to CDTFA, who I believe 30 minutes. So please begin your presentation.
Thank you. I'm going to give the bulk of the presentation, and at the end, Mr. Claremont is going to address a few points. But before we get to the substance of the appeal, we first want to clarify the department's role in these local tax matters. The department administers the allocation of local tax between the various jurisdictions that impose taxes pursuant to the Bradley-Burns Uniform Local Sales and Use Tax Law. When there is a dispute regarding the allocation of local tax, it is appealed via petition to the department's local revenue branch, and then to the Appeals Bureau. But the parties in a local tax appeal are the petitioning jurisdictions and the substantially affected jurisdictions. We also note that there are other jurisdictions that are not parties in this local tax appeal, in that they are not present here, but will otherwise be affected financially based on the outcome of this appeal as described in our Exhibit A, the decision and recommendation. There was mention of Regulation 30506 that lists the applicable section within the department as a party, but that is just for purposes of naming who's involved in the appeal process, not that the department is a party, meaning that the department would not benefit one way or the other with any financial gain or loss based on the outcome of these local tax appeals. With that in mind, Fillmore's contention that the department's delay in gathering evidence should bar any reallocation under the equitable doctrine of laches misses the mark. Laches provides a defense or bar to claims made by those who have neglected to assert their rights in a timely manner when the delay has caused prejudice to the party claiming a laches defense. Here, the petitioning jurisdictions timely filed their petitions. There was no delay by a party to this action, and any determination that the reallocation of local tax is barred by laches would punish petitioners for a delay they did not contribute to. Accordingly, there is no basis for applying the doctrine of laches to these facts. As to what specifically occurred during the period of August 4th, 2008 and September 26th, 2012, In its October 3rd, 2008 petition, Fillmore indicates that it was in the process of gathering documentation to submit to the department. The department acknowledged the petition in letters dated October 29th, 2008 and November 10th, 2008, and indicated that it was referring the matter to the Appeals Bureau. In December 2008, the Appeals Bureau returned the matter to the department for the issuance of a decision. The Appeals Bureau recognized, as was pointed out in the October 3rd, 2008 petition, that it was premature to refer this appeal to the Appeals Bureau prior to the issuance of the department's decision and/or supplemental decision. In February 2012, the department again requested documentation from Fillmore, which Fillmore responded to by email dated April 6, 2012, and letter dated April 16, 2012. The department issued its decision on September 26, 2012. There's no formal record of what transpired between January 2009 and February 2012. However, as has already been mentioned, this matter was one of 8 local tax cases involving the city of Fillmore that were all happening at the same time. Some of the other matters involved local tax that the department was holding in abeyance pending the outcome of the appeals. Also, unlike here, the amount at issue in those cases continued to accrue each quarter. Therefore, the parties informally agreed that the department would prioritize the other appeals ahead of this appeal at issue today. And during 2009, 10, and 11, the department worked to complete the other appeals before working on this appeal. And at that time, Fillmore's representative was representing Fillmore in all of the appeals. So it was beneficial to not only to Fillmore to handle the cases where the local tax was held in abeyance, but also to his representatives and to basically everybody that was involved. There had to be some type of prioritization to the cases so that they could start working them through and getting them resolved. Appellants here today have mentioned a few times in relation or in regard to this argument about latches that a lot of the evidence that could have been gathered wasn't gathered, and that's the prejudice that the city of Fillmore experienced, that they didn't know or couldn't foresee what evidence they needed to retain for when this case eventually came to an appeals, to the Appeals Bureau and eventually to the Office of Tax Appeals, which we find a little surprising given that the city of Fillmore was on notice in 2008 that the local tax was now I forget the term from the original letter, but that they were proposed to reallocate the tax from Fillmore to these other petitioning jurisdictions, and the questioning that has happened today kind of touched on the fact of why wouldn't Fillmore have, in anticipation of this matter going forward, why wouldn't they have kind of set aside the evidence as opposed to just kind of letting it go wherever it went? So the department is a little bit surprised by that admission. Turning now to the substance of this appeal, as I will explain in greater detail, the allocation of local tax to Fillmore was correct only if the applicable tax was sales tax, rather than use tax, and the place of sale was a location of the retailer in Fillmore. Pursuant to Section 6051 and Regulation 1620, subdivisions A and B, a retail sale is subject to sales tax if two conditions are satisfied. First, the sale occurs in California, which there's no dispute about that. And two, there's participation in the sale by a California location of the retailer. Here, there's no dispute that the sales occurred in California when the jet fuel was delivered to customer at the respective storage tanks at airports in this state. Therefore, the critical question is whether there was participation by any California location of retailer. It is undisputed that the storage tanks were not owned or operated by retailer, and that the fuel located in the storage tanks was commingled with fuel owned by other persons. The storage tanks are therefore not places of business of the retailer. Accordingly, the only location that could qualify as a place of business of the retailer is Inspired's Fillmore office. A place of business must be a place where the retailer actually conducts business, and generally must be a place the retailer has a proprietary interest in or otherwise holds out as its place of business. And you can see annotations 710.0013 and 710.0024. Where an agent working out of its own place of business performs activities on behalf of a principal, the agent's business location is generally not the business location of the principal. Here, pursuant to an agency agreement between retailer and Inspired Development, which is in Exhibit 1 to our Exhibit A, Inspired was required to lease or purchase commercial space necessary to create a regional sales administration center in Fillmore. The space was to be leased in Inspired's name and not as retailer's agent, and did not require retailer to make any payments. On or about September 28, 2006, representatives of retailer and its customer met at Inspired's Fillmore office at 751-F Ventura Street in Fillmore. Then on October 1st, 2006, retailer entered into a 9-year lease with Inspired for the non-exclusive use of office space at that location for a monthly rent of $100. That's in Exhibit 2 to Exhibit A. However, Inspired, not retailer, is listed as the occupant on the signage displayed on the building and door at the office location. And you see pictures in Exhibit 3 to Exhibit A. On May 7, 2008, the department visited the Fillmore office and found the doors locked and no one present, which is in Exhibit 6 to Exhibit A. The department also telephoned Inspired's landlord, who stated that he had never heard of retailer. There's also no evidence or contention that retailer's employees ever worked at the Ventura Street location. Instead, activities at the office were conducted by Joyce Cooperman, who, in her declaration, stated that she was the office manager at Inspired's Fillmore office. That's in Exhibit 12 to Exhibit A. In summary, there is no evidence that retailer ever held this office out as retailer's place of business in any way. The only time a representative of retailer was at that location was prior to the term of its lease, as one of two parties invited by Inspired to meet at that location. And at no time during the term of the lease did the retailer occupy or use the location in any way. Accordingly, the Fillmore office did not constitute an actual place of business of retailer. As such, no place of business of retailer participated in the sales at issue, and therefore the applicable tax is use tax, which is properly allocated through the county-wide pools of the jurisdictions of use, where the storage tanks were located. Now, while the foregoing is dispositive, we also address whether the Fillmore office participated in the sales. Participation in a transaction necessarily means that the local place of business of the retailer must have some meaningful effect on the sales process. That is, the participation must serve some real purpose in the actual sales process and involve some genuine physical interaction with the sale from that location. Activities that are not necessary for the sales process and or that take place after the sale is complete do not constitute participation in the sale. In addition, general business activities that support a retailer's sales activities do not constitute participation in any particular sale. Fillmore's first contention is that it negotiated the master sales agreement for all monthly sales at the Fillmore office on or about September 28, 2006. As explained in greater detail in Exhibit A, both parties at the meeting derived their authority to sign the agreement from the same person. That's in Exhibit 8 to Exhibit A. And the MSA was seemingly prepared prior to the meeting, with the only information added to the MSA at the meeting were being handwritten notations specifying the minimum and maximum limits of gallons to be purchased each month and the parties' signatures. And that comes from the declaration of Bill Corsi of Ryan LLC, which is in Exhibit C. No, sorry. That comes not from his declaration, but from the appeals conference transcript, which is in Exhibit C. Yet there's no evidence that the parties negotiated those limits, meaning the minimum and maximum gallons of fuel per month, at the meeting, or that they were authorized to negotiate at the meeting at all. Rather, the declaration relied on by Fillmore, found in Exhibit 11 to Exhibit A, which is Mr. Jones's declaration, makes the uncredible and unsubstantiated statement that the entire agreement was negotiated there. As such, while we have no reason to dispute that the MSA was signed at Inspired's Fillmore office, there is insufficient evidence to support that any negotiations took place there. And as previously stated, it was in fact Inspired's office, not retailers, especially not on September 28th, 2006, which was prior to the commencement of retailer's $100 a month sublease for the office space. And regardless, the MSA was not negotiated at the Fillmore location. Fillmore next contends that participation in these monthly statewide aviation fuel purchases occurred at that location through the actions of Ms. Cooperman, who we again note was an office manager at the Inspired office. The MSA required customer to order goods by notification to Inspired, including the quantities to be furnished. Specifically, the MSA reads, quote, "Customer shall notify retailer or Inspired when specific deliveries are required. Customer's delivery order shall indicate the delivery location, manufacturer, model number, quantity desired, and preferred delivery date," end quote. This shows that the orders required were received by retailer at its Houston headquarters when the amounts of fuel needed, the actual amounts of fuel needed, were provided by customer. Mr. Corsi confirmed at the appeals conference that the fuel needs were communicated by customer to retailer at the Houston office. That's again in Exhibit C. Customer would then issue a document to retailer indicating a range of how much fuel it needed for the subsequent month, Exhibit 7 to Exhibit A. These documents were issued a few days prior to the start of the month and were signed by Ms. Cooperman some days later. In response to these documents, on the same day she signed it, Ms. Cooperman would issue an authorization to release inventory, which is the name of the form, which indicates the maximum amount of fuel retailer was authorized to sell to customer for any given month. According to her declaration, found in Exhibit 12 to Exhibit A, Ms. Cooperman stated that, quote, "If the document was not correct, it was my duty to reject the order and notify the customer as to the basis for the rejection. If the document was deemed acceptable, I would notify retailer via an authorization to release inventory that it was permitted to release inventory to customer, end quote. Whereas the communications to the Houston headquarters put retailer on notice of the fuel requirements, any document received and inventory release form completed by Ms. Cooperman at best served only as unnecessary reminders. The documents she received stated an identical range each month, which actually incorrectly indicated the minimum and maximum monthly gallon amounts per the MSA. Yet, Ms. Cooperman never rejected the orders, indicating that the orders and Ms. Cooperman's actions bore no real purpose or had any real effect on the sale. In addition, for several of the months at issue, retailer released fuel prior to receiving the release forms, and each month retailer released more gallons than was authorized on the authorization forms. Again, indicating that the authorization forms were not actually necessary to the sales process. Based on this information, which is explained in more detail in Exhibit A, these orders and releases served no real purpose in the sale process and therefore do not constitute participation in the sales at issue. As to the argument regarding buying companies, we just wanted to make one statement about that, and then we'll reserve our further analysis of that argument in post-hearing briefing. But there's no dispute that retailer is a buying company, and that as a buying company, retailer is recognized as a separate legal entity entitled to hold a seller's permit for any location that meets the criteria of Section 6072 and Regulation 1699. However, there is no authority for the proposition that a different standard applies to buying companies with regard to what constitutes participation or a place of business of the retailer. We note in the Board of Equalization Memorandum Opinion, Cities of Agora Hills, a similar argument was raised by the City of Fillmore that a retailer's location was entitled to a seller's permit even though it did not meet the basic requirements of Regulation 1699. As stated in that memorandum opinion, Subdivision H of Regulation 1699 does not and cannot abrogate other legal requirements to the issuance of a seller's permit, including particularly as to the location to which a permit can attach. To summarize, the Fillmore office was never a place of business of retailer during the relevant periods at issue. Moreover, the September 2006 meeting and the actions of Ms. Cooperman did not constitute participation in the sales at issue within the meaning of Regulation 1802. For each of these reasons on their own, the applicable tax for the sales at issue was use tax, which was properly reallocated to petitioners and the other jurisdictions through their respective county-wide pools. Accordingly, Fillmore's appeal should be denied. And I'll let Mr. Claremont make statements.
Thank you. Good afternoon. To briefly respond to some of the arguments that have been raised by the City of Fillmore here, as Mr. Backus has explained, the issue here is based in the application of the basic allocation rules. Specifically, was there a place of business of the retailer and didn't negotiate or otherwise participate in the sales? Appellant here today, or excuse me, not appellant, the City of Fillmore here today has made a number of assertions as to why the application of those rules does not apply in this particular appeal or applies differently in this particular appeal, including the buying company rules under Regulation 1699I, formerly H, which Mr. Backus just addressed. None of those arguments are valid. For example, Regulation 1620 allows for participation by an agent, but only when working out of, quote, such places of business, such referring to a place of business of the retailer. Regulation 1802A1 states that if there is a sole in-state place of business of the retailer, it is the place of sale for all sales in which it participates. that is stated in that subdivision. So in both cases, the basic rule still applies. It must be a place of business of the retailer, and that place of business must participate in the sale. Likewise, with regard to jet fuel, Regulation 1802, Subdivision B6 discusses when allocation is to the place of delivery prior to 2008. It does not dictate when allocation is to another location. And in fact, the subdivision concludes in subparagraph E with the statement that otherwise tax is allocated as provided elsewhere in this regulation. With regard to Fillmore's discussion of another matter involving the sale of jet fuel, we note that the allocation of local tax is based on the facts and circumstances of each particular appeal or allocation. It is not the CDTFA's position that a buying company's office cannot be the place of sale. The question is whether, in a particular circumstance, the facts support that conclusion. For example, if a buying company actually placed an employee at its in-state office, held out that location as their place of business, and that employee genuinely took orders that had a necessary and meaningful impact on the transactions, then we would conclude that that buying company's office was the place of sale. As Mr. Backus has discussed, that is not the case here. It is the equal application of the allocation rules to a different set of facts and circumstances. With regard to negotiation, I note that the city of Fillmore has asserted here that these were essentially the same company, that these were not arm's length transactions, but rather a captive arrangement, I believe is how they've described it. And this position is not just at odds with the idea that the MSA was negotiated in the Fillmore office on September 28th, 2006, but that it was subject to deliberation at all at that point. If we are talking about essentially two entities that are acting as one, the contention here is that after internally developing this purchase agreement, this master sales agreement for however long that took, that this key element of the agreement, like the actual range that's going to be purchased, was left to the weekend before it was to take effect. And that, again, as Judge Wong has alluded to, it's hard to understand what form negotiation would take in this instance, but more than just negotiation, the fact that this wasn't already settled, if this was an internal deliberation of essentially two parties acting as one, it's somewhat unreasonable given the way that's been described here today with regard to the buying company arguments, that not only this would be left to be negotiated, but that it wouldn't have already been decided in this internal deliberation. So again, we do not believe that any negotiation of the master sales agreement took place in Fillmore. And then finally, I note that whether a location has been issued a seller's permit is not determinative of local tax allocations. The allocation analysis is based on the actual facts of the transaction. In almost all local tax allocation cases, such as this one, when a retailer is attempting to direct local tax to a specific location, it obtains a seller's permit for that location. It is a fact or a circumstance of pretty much all local tax allocation cases like this one, and it is simply not a relevant fact in determining the proper allocation of local tax. Local tax is based on the facts of the transactions themselves and the nature and the actual nature of the office itself, as whether it's an office of the retailer. Thank you.
Thank you. Thank you.
I did want to clarify. I made a misstatement in my conclusion when I said that the use tax was properly reallocated to petitioners and the other jurisdictions through their countywide pools. That's not accurate. Some of them were directly allocated for those transactions that were over $500,000. So I just wanted to clarify that we had some direct reallocation and some through the countywide pools.
Thank you very much for the clarification. I do have a couple questions, Mr. Backus. I just want to have it for the record. Does CDTFA dispute that retailer was a buying company?
We do not dispute that they were a buying company.
Okay, thank you. And I know you touched on latches and you spoke about it. However, can you please respond to appellant's assertion that because it went from like allocation group to appeals, back to allocation group. There was a misunderstanding and miscommunication to appellant, and therefore they weren't able to or did not provide the documents. Can the department please give its response to that?
Sure. We don't dispute that there was that it was prematurely sent to the Appeals Bureau at the end of 2008. And in discussing it with the Appeals Bureau, our understanding is that it was returned within a few weeks. That was that error was noticed and it was sent back. I'll just reiterate what I said before. The department just finds it hard to believe that a jurisdiction, knowing that local tax was proposed to be reallocated, that they would not retain documentation or evidence that could potentially stop that reallocation during the appeal process. The amount of time that seemingly no work was being done, or though we don't have any formal documentation that work was being done on this case, it was a long time, abnormally long. But again, there were other Fillmore cases for other companies, other retailers that were being worked through. So the fact that Fillmore is arguing that it was prejudiced by the fact that they didn't know to keep the documentation when they were going through these cases, with these other cases, and knowing that there was a proposal to reallocate the tax for this particular case, is hard to believe.
Okay, thank you. And I have one more question. I don't know if it would be best answered by you or Ms. Stoker, so I will let you guys decide after
Sure.
I answer this question. Ask the question. So in my minutes and orders, I asked the parties to address the 90 days of that. So my question is, it says, the regulation says, if the assigned section does not issue a written decision within 6 months of the date it received a valid petition, the petitioner may request the assigned section issue its decision, etc. So then I looked up what petitioner means. And so petitioner means a jurisdiction that has filed a timely and valid petition. So then I went, okay, well, what's the definition of a petition? And petition, the definition includes, as well as a jurisdiction's written objection to a notification that local or district tax previously distributed to the jurisdiction was incorrectly allocated and distributed to be redistributed. So my question is what CDTFA's position on appellant becoming a petitioner once appellant filed that filed the written objection? Does that start a 90-day clock for which a notified jurisdiction can ask for a written decision?
I will confer. So our understanding, or how it works, is the petitioners, in this case the jurisdictions that were petitioning the allocation to Fillmore, that's one way to petition. And then once there is a decision or a determination that the local tax will be reallocated, the objection to that is also a petition. So in this case, we have the petitioning jurisdictions, and then we have City of Fillmore, who is also a petitioner. All right.
I think there's two kinds of petitions, and we have both in this case. So we have the petitions that were filed by certain jurisdictions, which are the first kind of petition to get that money that was allocated somewhere else. Then for other jurisdictions, they did not file a petition, but we CDTFA notified the city of Fillmore that we would reallocate that money. We gave them notification, and then they filed an objection to that, which also became a petition. So they are also a petitioner. I think that is the petition. So I'm not 100% sure what the question is, but so the 6-month clock would start, if that's the question, would start at that point. In terms of after 6 months, they can request an update, request it be issued within 90 days. Request that the decision be issued within 90 days.
Okay, and I did my apologies, I misspoke when I read the regulation. I jumped the 6-month first. So I guess to clarify my question, once CDTFA, the allocation group, did not issue a formal decision in response to Fillmore's petition, and they did not respond, and correct me if I'm wrong, they did not issue that decision within that 6 months period. I was wondering if at that point the 90-day clock starts, for which Fillmore could then use that 90 days to ask for a decision to be issued.
I do not think so. I think that they would have had to. So their objection constituted a petition under 30506 B11. They would have had to make a request for a decision under 30506 C4. So
they.
Correct.
Okay.
And those are not the same thing.
Yeah, but Fillmore is. I guess because I understand petitioners can definitely ask for that decision to be made after 6 months. But my question is, would appellant also have that right?
Yeah, I'm not. C4 says only the petitioner would have that right.
Okay, thank you.
Yeah.
Just wanted to make sure.
Okay.
Thank you very much. Those are all my questions for the department. Judge Wong, do you have anything to add or questions, please?
I noticed Ms. Varney wanted to respond. I'd like to hear.
Well, I apologize because I missed addressing that previously, but I do want to clarify a little bit. I think that there was some overlapping in terms of our petitions, and there was also appears there was a petition that was filed by the city and county of San Francisco. And so I think that precipitated the original letter that went to the city of Fillmore back on August, that original letter where they were proposing the reallocation. And it's almost like the dates were identical of the petition. So I know from our perspective, when there wasn't a decision, and this is generally how we would view it, just addressing why we wouldn't have asked for it, a decision to be issued if it wasn't within that time period as called for in the regulation, is because we've just found that all that does is push an issue forward into the appeals process before the department has had the opportunity to really investigate the facts, and you aren't really gaining anything other than, trying to accelerate it before it's ready. And we've never, have found that to be favorable to the jurisdictions or anyone in that case. It's more important that the investigation be able to be completed and so forth, which was the reason that we did not ask relative to our petitions to have a decision to push it forward during that process.
Thank you. Thank you. I didn't have any other questions.
Thank you. Judge Brown, do you have any questions?
No, I don't have any questions. Thank you.
Okay, thank you. Mr. Cataldo, if you like, you may make a brief closing statement in response to petitioners and CDTFA's arguments, or further address any of the questions asked by the panel, but it is not required. Would you like to make closing remarks?
Yeah. Excuse me. Yes, just a few comments. The first comment is it seems that CDTFA and petitioners just want to disregard agency. I know I've said this already, but I'll say it again because it's pretty important. Inspired Development entered into an agency agreement with retailer. The agency agreement was specifically to open an office. They just want to disregard that fact when they're trying to apply the rule of place of business. Place of business was where Inspired Development was. It was there on behalf of retailer. So that's one. Secondly, with respect to buying companies, just because, like I said this before earlier in response to one of your questions, no, just because you meet the definition of a buying company alone doesn't mean you have a place of business. You could have a buying company in Antarctica. It's not going to get a California seller's permit. But here, there's only one location. It's a buying company, and we have ample evidence of its location being in Fillmore. Ample. As a result of that, the conclusion is that the local sales tax, because there's only one location, permitted location, one, it has to go there. And that's kind of the beginning and end of it. Just commenting on the Agora Hills case, that was a question of, okay, so you're a buying company, but you got more than one location. You don't get to just pick your location. That's kind of what I read that case as. We don't have that situation here. There's one location, or CDA, TFA, petitioner's position, none. We say one. So there's no, hey, where are you going to go between locations in California? The seller's permit, but there's one location, you have to, a seller's permit is issued to a location in California. I don't think you're going to issue a seller's permit to an office in Houston. This gets me to sort of stepping back and looking at the standard that you have to apply here to decide whether you're going to reallocate or not. A preponderance of the evidence. And we've talked a lot about all of the evidence that is pointing towards Fillmore. Now, I know they've picked apart little pieces, bits and pieces of this here. There was no sublease, that wasn't allowed, things of that nature. But what I'm not seeing is any evidence of the main contention, which is it's use tax because it happened in Houston. I don't think you can find by a preponderance of the evidence that with what's in the record. Excuse me. I did want to at least respond to petitioner's comment, which is true. I do not personally know what petitioners did during this time, and this is the Latches argument. I don't know. All I know is what's in the record, and the record shows nothing. As far as who's a party and who's not, there's a definition of party, and CDTFA is in it, if that matters for Latches. I don't think it does. Unreasonable delay and prejudice are the two things you have to find. That is all that I have.
Thank you, Mr. Cataldo. There was a couple of arguments made that from CDTFA that I was hoping you would be able to respond and give your response to. One was in regards to I wrote it on here. that the released authorization forms weren't really a participation in the sale because they were sometimes issued after the first of the month, and I believe they said also that the maximum amounts authorized to be released were in excess. The released fuel was actually in excess of the maximum amount authorized by the release, and so. Can you please provide appellant's response to that?
Yeah, so again, we've got to look to the master sales agreement. That kind of lays out all of the rules. And if you don't if these things were not issued, then you don't have a sale. If you don't have the authorization and POs issued, they're not a sale. The agreement recognizes that a lot of these things are estimates and they're not going to be 100% accurate at the time. Another thing I want to point out we keep saying participation in the sale, or I keep hearing that, and maybe that's just shorthand, but when you evaluate this, I would urge you to actually look closely and just read the letter of the law, the actual regulation. It talks about participation in the transaction in any way by the local office, branch, or outlet is sufficient to sustain the tax. I'm not sure if I answered your question. Maybe I have not.
Yeah, you did.
Okay.
Thank you. Ms. Judge Wong, do you have any questions?
I did not. Thank you.
Thank you. Judge Brown, do you have any questions?
I do not. Thank you.
Okay. I wanted to first ask, since it seems the parties addressed buying companies, I wanted to see if any parties still wanted to brief the issue. Mr. Cataldo?
We would be happy to brief the issues.
Okay, that's all. Thank you. I guess would be it. All right. I want to thank everyone for participating. Oh, I'm sorry, Mr. Backus.
I'm sorry, Mr. Claremont would like to clarify one of his answers, just to make sure there's no confusion, because we think there maybe is a little confusion with regard to the who can pull the trigger on those things.
And thank you. And I'm not even sure I'm still actually responding to the question, but just to be clear, the City of Fillmore was a petitioner in this case, and particularly since one decision was issued for all petitioners in this case, they could have requested a decision within 90 days pursuant to C4.
So, to clarify,
Yeah.
appellant could. As a petitioner.
They could because they were a petitioner. And again, even though they're a petitioner for only part of the case, there was one decision. So any petitioner could have requested that decision.
Okay. Thank you for the clarification.
Thank you.
Can I respond to that?
Yes, of course.
And just quickly, but the decision happened before the decision happened like in an instant. So they became a petitioner, but the decision happened. There was no occasion or ability to ever apply that because the decision was rendered. Like, we're done here. You're going to appeals. And that happened well within the time frame. The thing we're complaining about as far as the time and the latches argument is after that. Okay. The 3+ years after that, what happened?
Okay. Thank you very much. All right. I want to thank everyone for participating in the Office of Tax Appeals' first local tax oral hearing. If there is nothing further, I'm now concluding the hearing. The record will remain open to allow additional briefing on the issue of buying companies. Each party's additional briefing is limited to this issue of buying companies and its applicability to this matter. Any portion of a party's brief that addresses additional issues will not be considered by the Office of Tax Appeals. The deadline for appellant to submit its additional briefing is Tuesday, January 24th, 2023, which is 40 days from today's hearing. Petitioners and CDTFA shall both have 40 days to separately file a reply brief from the date that appellant's additional briefing is acknowledged. That would conclude the additional briefing process unless additional briefing is requested by OTA. At the conclusion of the additional briefing period, the record will be closed. The judges will then issue a written decision of our opinion of our decision within 100 days from when the record is closed. Today's hearing in the appeals of Cities of Fillmore et al. Is now adjourned. This concludes the hearing for today. Hearings will resume tomorrow at 9:30 a.m. Thank you, everybody.
Thank you.
Please cut the stream.
No, but I need an exhibit list. I was going to talk to whoever brought me up here to see if. And I can keep it? Okay, thank you. I think that's what you're asking for, right? Yeah, I need to put it in the transcript index. Yeah, okay. All right, thank you.